we are going to get started. Thanks for joining us tonight for another virtual program from Bozeman Public Library. If you did not hear the good news, we reopened for patrons to come inside yesterday. And so we're excited to see everybody's faces again inside the building. But for the time being, we are still continuing all of our programming virtually like this. And so this is part of our Dollars and Cents Financial Literacy Series. And tonight's focus will be on the fundamentals of estate planning with Miss Danielle Shine, who you've got on your screen right now. She is the owner of Shyne Law Group here in town, and she knows her biography far better than I do, and it will probably sound more natural coming up from her. So thanks for joining. If you have any questions, you can pop those in the question and answer segment or in the chat box, and I'll keep an eye on that, but we are going to address them at the end of the presentation. So I'll hand it over to you, Danielle. Thanks for being here.
Awesome. I'm happy to be here. Thank you, Corey. Like Corey said, my name is Danielle Shine. I am from Bozeman and got my law degree at Gonzaga University School of Law, who the Zags happen to be doing very well in basketball right now. I have been working in estate planning for the past couple of years. Seems like it's just gone by so fast. I worked for the Washington State Supreme Court and the Montana State Supreme Court, and then I worked for a large estate planning firm out of Missoula. And then over a year ago, before COVID, I went ahead and opened my own firm here in Bozeman. I practice mainly estate planning. Which includes a wide variety of things, but it includes guardianships, conservatorships, regular wills, trusts, basic estate planning, as well as Medicaid and veterans planning. Sorry if my screen is kind of shaking. My table is a little shaky today. So I live here in Bozeman with my husband and our two beautiful daughters. We have a puppy, and that's pretty much all about me. I will have a slideshow presentation that I'll be giving. I'm not sure if you'll be able to still see me during the presentation, but you'll definitely be able to see the slides that we're going through. And my main goal for this presentation is just to make sure that all of the participants walk away with an understanding of what basic estate planning is. Estate planning can be very confusing and intimidating. It's hard to know who to ask. A lot of people are getting information from second, third, fourth hand sources. So today I'm going to try to dispel some of those myths and give you guys some basic information about estate planning. Like Corey said, I will go ahead and present for about 35, 40 minutes, and then we can go ahead and have question and answers at the end. But feel free to write any questions that you have so you don't forget them, and Corey will keep track of those. Okay, so I'm gonna go ahead and share my screen. Let's see, we're gonna share this. Okay, can everybody see it? Corey?
Yes.
Okay, good. Okay, so estate planning basics. Like I said, I'm Danielle Shine. I am the attorney owner of Shyne Law Group here in Bozeman. We have an office downtown, but due to COVID, we also provide all sorts of online, virtual meetings, online and virtual meetings. So let's talk about estate planning. What is estate planning? Estate planning is basically, in the most basic terms, individual instructions and pre-planning regarding an individual's estate, which takes into consideration financial, medical needs, when we're thinking about future disability, incapacity, or death, right? So we're basically creating a plan for what's going to happen if you were to get ill, if you were to become incapacitated, and for when you do eventually pass away. Now, illness, we're talking more like, you get into a car accident, you're in the hospital, you need to be recovering, who's going to be in charge of helping take care of those decisions for you. Incapacity, we're thinking more about it, on Alzheimer's, early onset Alzheimer's, dementia, traumatic brain injuries, all of these things for incapacity. And then of course, death is passing away. So, sorry. Why plan? What's the point? I hear this a lot from clients all the time. I'll be gone, it won't matter. And I always tell them that, yes, that's very true. The state does have a plan. The state of Montana will determine who will get what you currently own or what you own when you pass after you do pass away. However, you would have no control over that process. Moreover, estate planning is more than just determining what happens after you pass away. It gives instructions to what happens while you're alive if you cannot give direction, right? So we talked about illness, incapacity. Those are the times when you need to be able to choose somebody to help take care of you. A lot of times, we are thinking about protecting ourselves and our loved ones. We want to make sure that if someone is taking care of us, making healthcare decisions on our behalf, making financial decisions on our behalf because we're no longer able to, we want to be able to choose who that person's going to be, whether that's a spouse or a child or a friend. This also provides peace of mind. Estate planning really can be cathartic because you are going to work with an estate planning attorney, usually, to walk through a lot of different scenarios and discuss what would happen in those situations. So once you've completed your estate planning, you should feel at ease knowing what's going to happen in a variety of different situations. Now, control is a big thing, right? Like I sort of said before, we cannot control a lot of things, particularly if we were to get sick or injured. But being prepared is something we can control. We can be prepared. We can know what's going to happen. And so that's something that we can work towards throughout our lives, no matter how old we are, how young we are, or what state we are in physically or emotionally. Additionally, this can avoid conflict within families. The world is becoming, there are more and more blended families all the time, late remarriages where two people get married in their 60s or 70s and they have adult children. These are all things that should be discussed and planned for so your assets can go to your children or charity or however you want things organized. So who needs an estate plan? Everyone. Everyone needs an estate plan. Depending on your age, your status as being married or divorced, widowed, being on a second or third marriage, giving birth to a child or adopting a child, inheriting assets from someone else, getting a disability diagnosis, having a business, changes in your assets or how those assets are held, are all great catalysts to get an estate plan going. But everyone needs the estate plan. A 30-year-old person's estate plan will look very different from a 70-year-old's estate plan. But it is important that there is some sort of plan in place. Again, I'm not as concerned about a 30-year-old passing away due to Alzheimer's as I am about a 70-year-old having memory issues. So that is where individualized planning and being able to find someone, whether that's an attorney or a program, that you can work with and feel comfortable with is so important. You're not just, writing a bunch of documents, you're planning for what's going to happen in the future. So estate planning can also provide a lot of protection, right? So it can protect your spouse, oftentimes from other, like from the children, or to protect the assets so they can continue living their standard of living, continue having their own standard of living. There's possible tax consequences for the spouse. If you have minor or disabled children, protection for the planner themselves. Like I said, if you got injured or incapacitated, so this estate planning can help protect you, obviously protect assets and property, ensure smooth transition and organization of your business, and also help if you are an active member of your community. A lot of people sit on boards or are part of organizations, and if something were to happen, it can be difficult to get off of those boards without having something in place saying, hey, if I get sick or something happens, let's get a new person in here who can help out the organization or the Bozeman Public Library, for example. Okay, so what if we don't have an estate plan, right? In Montana, under the rule of law, the courts and law determines who gets what after you pass away. The courts also will determine who will manage your estate, be guardians for your children, and all of that is going to be conducted in a public manner. Basically, a public manner means that it's going to be public record. Nothing will be published in the paper or anything like that, but anyone can go and review these public court filings. Family member disputes can happen if we don't have estate planning. Blended families, very large estates. Montana tends to be historically very land rich and cash poor. So chopping up a huge family farm for all 12 kids leaves not any child, no child would have enough land to continue the farming operation. And of course, possible loss of tax and asset protections. Okay, so we finally made it. What is included in an estate plan? So there's a lot of different ways to create your estate plan, but the main focus of your estate plan is going to be a will or some sort of trust. This document is how your assets are going to pass after you've passed away. A will or revocable living trust is sort of the center of the estate plan. Now, your durable power of attorney, your healthcare power of attorney, and your advance directive and HIPAA authorization are all what I consider incapacity documents. So your durable power of attorney gives an individual of your choosing power to manage your assets. Sign, your tax forms, get into your safety deposit box, manage the mortgage or pay bills on your behalf should you become incapacitated. Same with the healthcare power of attorney. The healthcare power of attorney is designed to choose someone to make decisions regarding your healthcare if you are unable to do so. An advance directive is also known as a living will, and it is designed to give information to your healthcare power of attorney, as well as any doctors or other medical individuals who will be taking care of you should you be in the hospital with a serious illness or injury. It's often sort of thought of as the document that tells the doctors, let me go peacefully without a ton of medical intervention, or do everything you possibly can to keep me alive. Now, a HIPAA authorization is actually an acronym for the Health Insurance Portability and Productivity Act of 1996, and it is basically a law that prevents doctors, dentists, any medical professional from giving medical information about you to anyone else. However, if you're sick or injured, you might want your children or your spouse to be able to get all of the information about what's going on with you. So a HIPAA authorization can be signed, and then the doctor will have the right to tell your children or your spouse or anyone that you designate medical information about you. Now, the durable power of attorney, the healthcare power of attorney, the advanced directive, and the HIPAA authorization all overlap, right? All these documents overlap. I like to think of it like Band-Aids on a ball. No one Band-Aid is going to cover the entire ball. So it's important to have all of them, even if they're going to overlap. A personal property memorandum is another document that is important to have in your estate planning, particularly if you are elderly. A personal property memorandum is basically a list of assets that you have that you want to give away to specific people. Let's say, for example, my mother and father have 3 children, and they want to split their estate equally between the 3 of us. However, there is property or assets that they have that they want to give to each one of us specifically. In the personal property memorandum, my parents could write down that I would receive, my grandmother's diamond rings or the jewelry, and my brothers would receive the tools and, the travel memorabilia. It allows people to, again, have a little bit more control after they're gone, and often can help prevent inter-family fighting over assets that might not be worth a lot, but are worth a lot emotionally for the family. So all of that on that side of the slide, that's your basic sort of estate plan. Now, again, depending on your age, your physical and mental health, your estate plan could look slightly different. Some of the other documents that can be used in your estate plan is a beneficiary deed, beneficiary designations, guardianship designations, life insurance, and irrevocable trusts. Now, beneficiary deed, or now called the transfer on death deed, is a way for people to transfer their home or other real property without a will. So instead of passing away and having your children go through probate, which we'll talk about in a few minutes, in order to get your assets, the beneficiary deed transfers your home or other real property immediately upon your passing. And all your children or whoever is getting the asset needs to do is to bring your death certificate to the clerk and county recorder's office. Same with beneficiary designations. If you have ever opened a brokerage account or life insurance policy, you have to list who's going to get the asset when you pass away. This sort of designation can be put on almost any financial account, any financial institution. There are the ability for you to put a beneficiary designation on assets is almost unlimited. Bank accounts, checking accounts, CDs, brokerage accounts, IRAs, your retirement accounts, life insurance, there's just so many out there. So again, instead of going through probate after you pass away, your children or whoever is going to inherit your property, they can just receive the property without having to deal with any of the probate. Again, guardianship designations, minor children, incapacitated children, you can put that information in your will or in a separate document, making sure that whoever is taking care of your assets and your family after you pass knows who you want to take care of everything, who's going to take care of the children. Life insurance is also a great estate planning tool that people don't really think about. A lot of times there will be situations where money is needed to pay off a mortgage or to pay off another asset, and life insurance can be used after you pass away to pay off some of those assets. Irrevocable trusts as well are very popular. These can help protect your children, your spouse, and even yourself, depending on what sort of trust we're creating. Okay, so let's get a little bit more specific about all of these. So will, this is an instrument which directs how your assets will be distributed, who will manage the estate, how your expenses and taxes will be paid. So it will determine how your assets will be distributed. It can say, equal shares to all of my living children. It can say everything to Mary Jo. It can say everything to the Bozeman Library Foundation. It can say whatever you want it to say. You also will choose who's going to manage your estate. So this is the person that you trust to properly pass out all of your assets after you've passed away. Usually this is a spouse or a child or a trusted friend, but can also be a company or third-party organization. Again, you can nominate your guardians for minor or incapacitated children through the will. And again, you'll choose your beneficiaries. In Montana, when you pass away, all of your expenses and taxes will need to be paid. Like if you made any income that year, you'll have to pay income taxes, property taxes, you know, your last funeral expenses, you know, the mortgage payment, the electric bill, all of these things are going to have to be paid after you pass. And the will can help direct how to do that and who's going to be in charge. Now, a will does not control anything that has a beneficiary designation on it. So again, let's say you have a will that says give everything to my 3 children equally, but you have a life insurance policy that says give the life insurance policy to child A. Child A will receive the entire life insurance policy and will not have to share it with child B or C. In Montana, all you have to have for a will is to be 18 years old, of sound mind. You have to sign and date it, and it has to be witnessed, which is often a barrier for a lot of people, especially with COVID. Normally, we would just go into a bank or at your work. People can witness it. It's not a big deal. But with COVID, we're just not able to do a lot of that. So I found that it can kind of, that sort of witnessing can cause some barriers to people actually getting their wills executed. Okay, so a revocable living trust. Now, a revocable living trust is what we're talking about when people say, I have a trust, or I'm a trust fund baby, or, you know, I set up a trust for the kids for after I pass away. 99% of the time, we're talking about a revocable living trust. I like to think of revocable living trusts like a cup. You meet with your attorney or someone, you go ahead and create all the paperwork, which creates your cup. It allows for centralized management of your assets throughout your life. So you create the cup and you retitle your home into the cup, your bank accounts, your assets, your cars, everything pretty much can go into the trust. Then you will have full control of everything in the trust while you're alive. And if you become incapacitated and when you eventually pass away, you will have named someone to manage the trust, the cup, after you pass. That person will be able to use any of the trust assets, right, to manage your estate. You pay the mortgage, pay last funeral expenses, keep the lights on at the house, because everything will be owned through the trust. And once you pass away, the new person will be able to manage everything. A trust also provides significantly more protection for your heirs than a will does. It can provide protection for if your child is going through a divorce or bankruptcy or a lawsuit, or if they're incapacitated, their assets can actually be held in that trust until the lawsuit is over, after the divorce. So they're not going to lose their inheritance just because you passed away while they were going through a divorce. Trusts also help do estate tax planning. A will can definitely do estate tax planning as well, but a trust makes it a little easier and gives you the opportunity to practice using the trust before you or your spouse passes away. It generally does not provide protection, you know, against bankruptcy or divorce or creditors for the actual person who creates the trust. And it doesn't protect against costs of like long-term care or anything like that. Everything that's in the trust is still owned by you. Okay, so a little bit of review here. So a revocable living trust is going to avoid probate. It's going to sort of reduce taxes, plan for assets, protect minors or people who would go and spend their entire inheritance in one fell swoop, provides more privacy. Expenses can be paid prior to death. There's not going to be a big expensive attorney bill after you pass away because you will have already paid the attorney or whoever prior to that. Immediate access to assets for your beneficiaries, avoiding guardians and conservators, and less complex and will contests. Where a will does provide some benefits, like the cutoff for creditors claims. Again, it can protect minors or spendthrifts, and the expenses will come after passing as opposed to before passing. Again, spending some time with an estate planning attorney or someone who's knowledgeable about estate planning will be very beneficial to ensuring that you have the right plan. Trusts can be more complicated and wills are less complicated. So there's lots of factors that go into what is best for you and your family. Again, we talked about the personal property memorandum a few minutes ago, but again, it really distributes all of your tangible personal property. So that's all your junk, your socks and underwear and pots and pans and TV, anything that doesn't have a title, right? So not your house, not the car, not the four-wheeler, all of the stuff in your house. And so you can make these specific bequests to anyone, and it can be flexible and it can be updated anytime by you in the comfort of your own home. You don't have to go back to the attorney once it's created. Beneficiary designations, again, we've talked about this a little bit, is designating beneficiaries for your assets. Particularly, I like to use a lot of beneficiary designations if we have maybe only one child, or there just isn't a big need to have a complicated trust. We just put beneficiary designations on all of the assets so everything goes to that one child after you pass. Asset titling, of course, those transfer on death deeds, transfer and pay on death designations are how what banks call the beneficiary designations for the most part. So if you wanted to make sure that your bank account goes to your kid after you pass away, but you don't want your child to be an owner of the bank account while you're alive, you can set up these transfer or pay on death designations. Okay, so a little bit about long-term care planning. Like I said before, a lot of my practice is estate planning, but then also long-term care and veterans planning. And this is a really important thing to think about when you're doing estate planning, because you might have assets now, but what happens if you or your spouse gets sick or injured? Medicare does not pay for long-term care at all. They will pay for a few days if you end up in the hospital for 3 days, and all these things. There's so many hoops to jump through for them to take care of you and pay for things, and then it only lasts a few months, and the amount that they pay, the amount Medicare pays, goes down every day, and you pay a little bit more of the total cost. Again, planning for possible need for long-term care can be done through long-term care insurance, irrevocable trust, and other planning, just to make sure that we have, again, some sort of plan should the worst case happen. Okay, so like I said, we do irrevocable trusts. These can be very helpful when planning for possible incapacity. An irrevocable trust is basically where you take an asset and you put it into a cup, right? The cup analogy, and you cannot get it back out of the cup. So the revocable living trust, you have power to put anything in the cup and take anything out. An irrevocable trust, once you put it in there, you can't get it out. Now at that point, right, you will appoint someone, a child, a trusted family member, a trusted friend, an attorney or other fiduciary, to manage whatever's in the trust. So you can still get income from the trust, or use the assets, like if your home was in the trust, but it's going to limit what is in your estate. So that can be for like Medicaid or veterans benefits, or depending on how it's created, once you pass away, that asset can be pushed out of your estate plan. pushed out of your estate for tax purposes. Okay. Again, this also provides significant protection for beneficiaries after you've passed away. As we talked about a little bit before, these are the 4 documents that are necessary for planning for incapacity. You don't have to get all wild and create a big trust or an irrevocable trust, or give away all your stuff thinking that you're going to be ending up in assisted living or get Alzheimer's. The most important thing is to make sure that we're putting down on paper who's going to be managing what if something were to happen. Who's going to take care of all my financial stuff? Who's going to make healthcare decisions for me? What happens if my healthcare power of attorney isn't available? I want to have a document that tells the doctors how I feel if my death is imminent about invasive procedures. And of course, HIPAA authorizations to make sure that if anyone needs medical information about you, that they can get that. Sometimes I like to explain to people, right? Imagine you go to the hospital in a car, like you're in a car accident and you end up at the hospital. You have got a number of injuries, and so you're in a medically induced coma. Now, because you're in a coma, you're not going to be able to make a decision about whether you're going to get a metal or ceramic hip when they do the surgery. Your healthcare power of attorney can make that decision for you instead of the doctors or the bean counters of the hospital making that decision. Now, let's say you're doing better, you've gotten out of surgery, but you're still not capable of dealing with anything. Your durable financial power of attorney can then step in. Let's say if there's a problem with the insurance company. The insurance company is not paying this bill, or you're out of network, or something that happens with insurance. Now you have a durable financial power of attorney who can talk to the insurance company and argue with them and get everything that they need in order to have the insurance cover the injury and the hospital visit. In order to get all that medical information that the insurance company needs, the durable financial power of attorney is going to need that HIPAA authorization. So you can see how they all sort of work together that way and why it's important to have all of them. Okay, again, we talked about the durable power of attorney a little bit. Again, gives you the power to another to manage and protect your assets if you become unable to do so due to illness, injury, or age. This document, again, you're in complete control of it. You can choose who's going to do it. You can choose when it's effective, and you can determine what sort of powers your power of attorney is going to have. The only thing that people sometimes get confused is that after you pass away, your durable power of attorney is no longer powerful. So after you pass, someone can't, your power of attorney can't go to the bank and get assets or do something like that unless there's another designation like in your will or on the actual account itself. Okay. Healthcare power of attorney, we talked about this. I'm going to give you power to another person to make medical decisions and healthcare decisions on your behalf if you're unable to do so. So you can imagine, right, you are going to make all of your medical decisions for yourself until you are no longer able to do so. When a court or doctor decides you're incapacitated or you're in a medically induced coma or something, your healthcare power of attorney will step in and make any decisions that need to be made. You can name a bunch of people to be your powers of attorney. You can have people work together. You can have daughter A, son, kid A, kid B, kid C, all on the list. So if one of them cannot be there or be the power of attorney, then you have backups. And only after all of your healthcare powers of attorney are not available, or they're in the same car accident or something like that has happened, does the advanced directive come into play. So you make your own decisions, then your healthcare power of attorney makes decisions for you. And if the healthcare power of attorney is not available or you don't have one, then the doctors and hospital staff will look at your advanced directive. So you're going to appoint either an individual or just provide instructions to carry out end-of-life decisions in the event that you are unable to do so, right? So it's not that you've got a diagnosis and they're saying you only have a week to live. It is that you are not waking up from surgery, right? Like you're not able to make a decision about whether or not you're going to be intubated or whether you're going to get fluids or whether they're going to do additional surgeries. An advance directive is only valid when you have a terminal condition, you are persistently unconscious, you are normally on some sort of life support, and you're in what's considered an end state condition, that there will be no recovery and death is imminent in this situation. Over here, we have different choices, right? So there's a whole, because these documents are yours and they can be written however you want them, there's a whole broad range of how you can do it, right? So no life-sustaining treatment, no, maybe nutrition and hydration, pain management, all the way up to, life-sustaining treatments, invasive procedures, anything, anywhere on that scale it can talk about. Now, I know that this particular document can be very sensitive for a lot of people, and this whole conversation can be very sensitive for a lot of people. I am of the opinion that everyone is going to eventually pass away. And it is so important to make sure that you're having conversations with family members and children and spouses about what you want, because they're going to be the ones making those decisions. It's hard enough to lose mom or dad without also having to make all of these decisions right after they pass away or when they're in the hospital, okay? So a few more things for us to go over before we get into our question and answer period. So LLCs can also be used in estate planning. An LLC is a limited liability company. A lot of time it's sort of like a trust, but different. But you can put real estate, mineral deeds, interest, business operations all into an LLC, and you can actually transfer them to whoever is going to manage your business after you pass away without having to deal with probate or closing the business or restarting the business or doing anything like that. All of the operating agreements will explain exactly what's going to happen. LLCs can even be owned by a revocable living trust or even an irrevocable trust. So again, this is why it's so important to definitely talk to someone who you feel comfortable with, who can go over a bunch of different options with you. Again, minor or incapacitated children is a huge catalyst for people to start thinking about estate planning, appointing guardians and conservators for the kids if you were to become ill or injured, possibly establishing trusts for those children to protect assets, pay for care. Minors cannot inherit assets outright. So whether or not you plan for it or not, those assets will be held for those children, and it might not be held in a way that you would want them to be held. So planning ahead, making sure that, grandma's going to be in charge of the kids' money and you want them to go to private school, all these things are listed in your paperwork. And then of course, supplemental or special needs trust can be set up for incapacitated children. So let's talk about probate real quick. What is probate? So after someone passes away, probate is the process by which assets are transferred, debts are paid, taxes are paid, and the affairs of the individual are wrapped up after passing. There's sort of an old colloquialism is that they say probate is how the government closes the books on you after you're gone. In Montana, it can be formal or informal. So you do have to file with the court, but you can do it in front of a judge or not really have a lot of judge or court intervention during the process. Montana does have a relatively basic probate process. In California, the probate process is so horrific and so awful and so time consuming that almost every single person has a revocable living trust, because a revocable living trust prevents probate. You don't need the court to determine who's going to get your stuff if you have a trust, because the trust will manage all of that. Probate also uses your will to appoint that personal representative and determine how your assets will be distributed. So the process of probate, someone passes away, we have to petition the court. We have to nominate the personal representative, and the court has to accept the will, or if there's no will, accept the fact that there is no will. Inventory and marshal any assets that are out there, whether they're in Montana or outside of Montana. Notice to creditors, heirs, beneficiaries, anyone who has an interest in your estate. Pay any income or estate taxes, pay debts, distribute the assets to whatever beneficiaries are designated, and finalize accounting and closing the estate. Like I said, sort of closing the books, making sure all the bills are paid, making sure everything gets taken care of so they can officially close the books. So when we're thinking about this probate, right, we want to think about what's going to happen if you pass away with a will. Those are all of the assets that you're going to own yourself outright, individually by yourself. So like my husband and I own our home together, and we own it as joint tenants with right of survivorship. Now that means that our home is a non-probate asset. If I or my husband were to pass away, the home would automatically become the sole property of the surviving spouse. Okay, so you wouldn't have to go to court, you wouldn't have to go through the probate process for those jointly held assets, you know, a house, a bank account with both you and your spouse's name on it, or you and your child's name on it. Anything that's in a trust. So that revocable living trust will prevent probate as long as everything you own is in that trust. Life estates, another way when we're thinking about passing assets on, and assets with the beneficiary designations. So all of those assets do not go through probate, where anything that you own individually, that's not jointly owned, that's not in a trust, will have to go through probate. So depending on the complexity of your estate, your desires, your ability to manage a trust, after someone passes away, we can distribute assets without ever having to go through probate if we've made plans beforehand. Okay, so quick note about estate taxes, because everyone has questions about estate taxes. These used to be called death taxes, but now we call them estate taxes. So death taxes or estate taxes are a tax that is levied by the state and or federal government on the assets that you are giving away when you pass away. A lot of people don't like this. They feel like it's double taxation. You have already paid the taxes on it, and now in order for your child or your spouse to get it, you're gonna have to pay taxes again. So in Montana, there is no estate taxes. You do not have to pay the state of Montana taxes when you pass away in Montana. Do you still have to pay income taxes? Do you still have to pay the property taxes? Absolutely. Those are still taxes you have to pay, but there's not going to be an estate tax. A lot of times people get confused about, you know, like you inherit an IRA or an investment account, and that money was never taxed, right? It was put into the account pre-tax. Of course, taxes will come out of that as well. So any taxes that would have been due by the person who passed away will still be due afterwards. Now, the federal government does have estate taxes. In 2021, the estate tax limit is $11.7 million, and each spouse gets $11.7 million if you're married. So what does that mean? That means that if you are single, you do not pay estate taxes unless you pass away with more than $11.7 million. If you're married, that number goes up to $11.7 million times 2. So we're looking at like $23 million. Then if you do have assets over that limit, you pay estate taxes on the amount over the $11.7 million. Now this includes, when they're calculating your $11.7 million, that includes all of the gifts you've given during your lifetime, as well as the assets you owned at death. What about the gifts? They only count gifts. The IRS only counts gifts that are over $15,000. And so you do not have to, you don't count the birthday cards or the $1,000 you gave your child to fix the car or something like that. If you do have an estate that could be over $11.7 million or 23 million if you're married, estate planning is going to be very beneficial to you. It will provide major tax benefits. I think right now the estate tax limit is 40% on anything over $11.7 million. So it's going to take a huge chunk out of your estate, particularly individuals who've created a successful business or inherited large ranch properties. $11.7 million seems like a lot, except when you start calculating all of the business assets or ranch assets. And again, when you're married, there's a lot more opportunities to prevent these taxes from having to be paid. But again, you got to talk to an estate planning attorney or someone who knows what they're doing. Okay, so that is my whole presentation. Again, my name is Danielle Shine, and I am the owner of Shyne Law Group here in Bozeman. My address is there on the screen, as well as my phone number and my email address. I know that you'll be able to reach out to the Bozeman Library Foundation if you don't write any of this down and you do want to contact me. Again, I think estate planning is just so important, and I think that everyone needs one, whether it's super simple or super complex. It's just something that everyone needs to do, and it's going to make a difference now and in the future. Okay, so now we're going to stop sharing my screen.
Okay, Danielle, we did have a few questions, and I'll start with the ones that we're about 15 minutes in. Sure. First question, since Montana is a common law state, does a long-term partner have the same rights as a married partner? And what about Social Security benefits? Do those transfer to a common law partner like they would to a spouse?
Okay, so Montana is not a common law state. It is also not an independent state. Montana has to be different. So we are what would be considered a fairness or reasonableness state, okay? So we take things from community property states and we take things from non-community property states and we sort of mush them together and say, this is how we're gonna do things. So first things, a long-term relationship does not create a common law marriage. A common law marriage requires specific things. You have to hold yourself out to be married. That means that you tell your relatives and your friends that you guys are married. You live together and you receive mail or pay bills together. I'm not saying that people are, both of your names are on the electric bill, but John pays the electric and I pay the water, right? You're both contributing to the household. And you have to be married, you have to be in this relationship for a significant period of time. I think in Montana right now, it's only 6 months. So common law marriage can happen relatively quickly, but you have to be, you have to be married. You have to act married. You have to tell people that you're married. And if you do that, you have the same rights as a spouse when your long-term relationship partner passes away. In Montana, we recognize common law marriage. Once a state recognizes your marriage, the federal government recognizes your marriage. So as long as the state of Montana recognizes your common law marriage, the federal government, Social Security benefits, all of that kind of stuff will also recognize the marriage. Even like the VA and such will recognize the marriage. So you'll be able to get any benefits that way. But you have to prove that you were common law married. Right? So I've talked to people before who are like, well, we've been in a relationship for a long time, and I always called him my husband, but he was always very clear that we were not married and never called me his wife and all of this. If the husband or the male in the relationship were to pass away, there would not be a common law marriage. Okay, does that answer your question?
And then the other question we received about halfway through the presentation If you are not listed to receive any assets from someone's estate, but you find out you are listed as the individual to manage their estate once they've passed away, if you do not want to serve in that capacity, do you have any legal obligation to do so? If other family members ask you to sign a renunciation form to relinquish your role as the administrator, should you do it? And are there negative consequences? And what kind of role should a lawyer take?
Definitely. Okay. So again, this question has a couple different aspects to it. So let's take them one at a time. So let's say, I like to use examples because it makes things easier to organize in our mind, right? Let's say your best friend passes away and she wasn't married, but she had children. She listed you as the personal representative. That's what it's called in Montana, not the executor, the administrator, personal representative. So that's what it's called. And she's listed you as that person, but you're not going to inherit anything from her estate. Now, you can get paid like income from the estate to manage it. So that means that, if you spend any money and all the time you spend will all be paid by your friend's estate, right? Her bank accounts and all of this kind of stuff. If you do not want to serve in that capacity, you do not have to. You are not required to. You're not legally bound to do so. So you can, yes, sign a renunciation. That's what it's called. So if you're named in a will as the personal representative, the only way you can get out of it is to sign the renunciation, because the court will not appoint a different personal representative until you've renounced your position. Now, if you're in jail or you've passed away or you're, in a memory care unit with severe advanced Alzheimer's, yeah, you're not going to be able to sign the renunciation, and the court will nominate the next person listed in the will. Or again, the law writes down exactly what order people are going to be the personal representative. So if the other family members ask you to sign a renunciation form and you do not want to be the personal representative, there's no danger in signing off, right? And signing the form for you personally, right? If your best friend nominated you as the personal representative and it's her two children who are 18 and 19 asking you to renounce your position as personal representative because they want to be in control of all the assets, maybe it could be a little detrimental for them, right? Because the personal representative is going to have this power to, hey, these kids are pretty young, like the will says we can put the assets in a trust, till they're 25, if I think that's right. So there's all these things that could happen that could be beneficial or detrimental to the beneficiaries. But for you personally, renouncing, saying you don't want to be the personal representative will have no negative legal consequences for you. Should you go through a lawyer? So if you know that you're listed as a personal representative on someone's will, you can go take the will after someone passed away, right, to any attorney, right? Any attorney that does probates and estate planning. And that attorney will be able to walk you through what is going on, what your roles are going to be, what duties you have, what power you have during the probate process, and also explain to you your right and your ability to renounce that position. I think I said at the beginning of the conversation, a lot of this conversation comes from people's personal experiences, right? So a friend's family member dies or someone's parent dies, and maybe they had a really bad experience, so they don't want to be the personal representative, or maybe they've never done it before. That's why the courts have created a process that you can go through, and why attorneys usually handle probates, because it is complicated and it can be frustrating. And that's why you need, a partner. There's certain companies in town that will do probates, or attorneys. So I always suggest, talking to an attorney, at least at first, right? If the attorney can also guide you if it's a small estate on how to do it yourself if you're so inclined. So yeah, I hope that answers your your question. So it doesn't look like we have really any other questions right now. I know that there's not a ton of attendees here, but I do appreciate all of you attending. You know, I think that knowledge is power. It's really important to make sure that we're thinking about all of these things, right? We make plans for everything. Most people put more effort into planning a birthday party than they do into planning what's going to happen if they become incapacitated and when they pass away. So I just encourage all of you to talk to your family members, talk to your friends, you know, see what they're doing. Find an attorney that you trust, find an attorney that you can work with, someone that's easy to talk to and can explain things to you, and just get that estate plan done. You know, it's gonna provide a lot of peace of mind if we can get it done.
Thank you so much for being here tonight and sharing your wisdom with us. And it looks like there was one last question popped in just now. Do you have a recommended number of executors? It's a lot of work for one person.
Yes, so the answer is one. So you can have, the main concern when we have co-executors is that what if they don't agree, right? So if they don't agree, then your probate has just doubled or tripled in cost because now we have to go to court and have the judge decide who's right or wrong. And if they can't agree on every single decision, then we're going to court constantly to get the judge to make decisions about things. I suggest when my clients have questions like this, right? One, you are going to appoint the most responsible person in your wheelhouse to be the personal representative. It's not always, you know, your favorite child or your first child. It is going to be someone who's going to be able to manage stuff and manage the family. That's also why you have an attorney. You know, I have a lot of clients who hand me the paperwork and say, I don't even want to think about it, right? I want you to handle everything. I want you to hire the people to do this. I'm willing to pay for it because I don't want to do it. It's a more expensive process, but they don't have to worry about it. And then I have clients who are saying, you do only what you need to do to make sure I'm doing this all legally and provide me advice, but I'm going to take care of everything else. Okay. So there's this whole wide variety of support that you can get after someone passes away. But I always suggest just one representative. I guess you could do 3, right? You need to have a tiebreaker vote or 5. But it can get quite complicated and frustrating for the family as well. So pros and cons on both sides. Okay, well, I see that it's 8:03, so I don't want to take up any more of your time on this beautiful evening. Thank you so much, Corey, and thank you to the Bozeman Library Foundation for inviting me to come and speak to you. You know, Corey, if you ever have any questions or need anything else from me on behalf of the Bozeman Foundation, or if any of the attendees need anything, you know, feel free to reach out at any time, okay?
Thank you so much. Have a great night.
You're very welcome. You too. Bye.